Jury selection's underway for the Jonathan Majors trial, and we're going to take a look at what happened during the pretrial hearing this morning. Look at a quick arrival video of Jonathan Majors, Megan Good, and Priya Chaudhry, and then talk about what's going on with the balancing act between the First Amendment and the Sixth Amendment and the press's access or ability to access parts and pieces of this trial versus Jonathan Majors' right to a fair trial. So let's jump in. What we're going to be looking at today is coming from sources that are at the courthouse and doing the reporting, because remember, this case is not being live streamed anywhere. It's not being televised. And as we're going over this, even though we have some information from the earlier half of this day, currently the courtroom is closed to the public. Not even Megan Good is inside. So that's just to contextualize how we know what we're going to be able to look at here. So let's go in order of how the day went down. We have Emily Palmer with People. She's reporting from the courthouse. And she took this video of Jonathan Majors entering the court holding hands with Megan Good this morning. This is Priya dressed for Windsor.
Oh, let's see.
The height difference is crazy.
Nice. Okay.
And he says thank you to someone that wishes him good luck, but he doesn't comment to anyone else. And then to break down what's going on the rest of this morning, we're going to look at a combination of what the Associated Press is reporting. This is through Jake Offenhartz. And then we're going to look at two reporters that are down at the courthouse, at some threads that they've put together on X. I'll link to all of these things in the descriptions. That way you can go and look at them yourself. But we're going to overlap the details that all of them are bringing in, because remember, this is not televised. This isn't something you can press rewind and go back and make sure you heard something correctly. And it's not the easiest thing in the world to try to document while things are happening in front of you, especially, we don't know, but there could be people talking over each other and who knows. So as we go through this again, remember the nature of the reporting. So from Jake Offenhartz here, we have a picture of Jonathan Majors arriving. That's the security detail, and then Megan Good right in front of him. And then we see that he arrived carrying a Bible and one of his signature coffee cups. He didn't speak during the start of the proceeding, and although the rest of this part goes over some of the same details that we've already heard over and over, Major's defense team reiterated in court that police who responded to the scene where the arrest was made, where he was arrested, that they did not interview Majors, and that Manhattan prosecutors have refused to review evidence showing that he was the victim. We also get this next detail about Grace Jabbari's arrest. On Wednesday, the judge, Michael Gaffey, who we've seen come up before in some of the other reports from other court hearings, he described the brief arrest of Jabbari as very unusual, suggesting that Major's celebrity status may have played a role in the police department's decision to charge his accuser 3 months after the incident. And this whole line is in quotes. Quote, "Did this only come about because of the high-profile nature of the case? ? End quote. Gaffey asked the court. Quote, "If this was an indigent, everyday New Yorker, would this arrest have happened? ? End quote. Now, indigent in the legal sense means someone that can't afford to hire proper defense. And as some food for thought, if we want to pick and parse at the way this quote is asked, did this only come about because of the high nature profile of the case? If he was an indigent, everyday New Yorker, would this arrest have happened? It seems very wisely worded to me, because it's inquisitive and not suggestive. If you think about it, it's not really suggesting that the arrest should or should not have happened. It's suggesting that, oh, this arrest actually happened, but is it only because this person had the resources to make it happen? Someone having the resources to make something happen doesn't mean it's the right or wrong thing to happen. At least we're not getting further conclusions or characterizations here from Gaffey. Gaffey isn't seeming to lean one way or the other with this. But one person could say, hey, this arrest only happened because he had the resources and pushed someone to do it, and it shouldn't have happened. But on the other hand, you could say, like, hey, for people that don't have these resources, that maybe feel a crime was perpetrated against them, are there cases where the police don't take action? Because that opens up a whole nother line of conversation that the justice system should always be thinking about. But that's just my food for thought. And remember, these quotes that we're getting, it's probably all moving very fast in the courtroom. So just based on what I know, I do appreciate that this is like a sharp question without explicitly seeming to lean one way or the other, even though it's open for someone to interpret how they want to on either side. But moving on here to this paragraph right above this picture, Before jury selection could begin Wednesday, attorneys for Majors successfully sought to bar the public and press from the courtroom in order to before jury selection could begin Wednesday, attorneys for Majors successfully sought to bar the public and press from the courtroom in order to discuss evidence in the case that has not been made public. The attorney, Seth Zuckerman, who we saw on some of the filings, he was, undersigned counsel, warned the evidence could, quote, taint the jury pool beyond repair for Mr. Majors, end quote, adding that his client may face, quote, trial by newspaper, end quote. And if you've been following along with this case, that's nothing new, right? You've probably heard me say that we've got Priya Chaudhry going to Insider, and then you've got the prosecution who seems to be having a two-way conversation with the Rolling Stone, Cheyenne Roundtree, and Tatiana Siegel from Variety. This is a great time to add in that Flavio sent me this yesterday. So Roland Martin has been covering these things that are going through the Manhattan DA's office. Priya Chaudhry jumped on to have a conversation with him about the Adam Foss acquittal. He was fully acquitted. And some of the things that the prosecution did during jury selection, like try to get one potential juror stricken who is a black man with an MBA from NYU. The prosecutor tried to strike him as a juror, apparently, because she did not think he would be able to understand jury instructions. So there's a lot of interesting stuff in this interview that doesn't specifically pertain to the Jonathan Majors case, but can inform a characterization or an assessment of the Manhattan DA as a whole. And at the very end here, we get this clip where
is what Alvin Bragg's office is pushing. And we saw it in the Foss trial. That was a felony rape trial. And they do not care about evidence. They do not even keep their mind open to this black man might be innocent, right, and I should believe him.
And again, just making sure there is a gag order in the Majors case.
I'm not allowed to discuss that case, and I respect that.
Got it.
Thank you.
All right.
And the reason I point that out is because stuff has died down since all that noise we heard on the eve of the last hearing in October, where we had everything being published on the 24th and the 25th. The hearing was on the 26th. I think it was the 26th. It was like article after article. It's when Rolling Stone and Variety had these bombshell reveals about a mystery London September 2022 event. It's when the arrest of Grace Jabbari happened. She turned herself in. Charges were dropped immediately. Her lawyer gave a statement saying that he knew and was told personally that they would be dropped immediately. That's when that whole mess was happening. And everything seems to have died down, but yesterday, it being the eve of the trial start, I was curious what was going on, and then I did my video yesterday on the Rolling Stone article that came out, and it seemed like Rolling Stone was treading really lightly, where they couldn't just come out and say that there was something new that they could talk about or that they heard it from the prosecution. You can check out my last video to see if you get that same vibe, but it seems like the judge has been like, stop taking this to the press. And we're going to see this sentiment echoed through what we're able to see from this morning's pretrial hearing. So if we get back over here where we see that Seth Zuckerman argued that unsealing all this Molyneux evidence that's currently sealed, if you want a greater understanding of what Molyneux evidence is, it was in my video yesterday. But we have a pretty good guess from the Rolling Stones reporting that the evidence the prosecution is including in their packet that they're trying to submit through this Molyneux application rule are the witness statements that came from the same witnesses that Rolling Stone wrote that big article on back in the summer, where a lot of them were third-party witnesses that heard from someone else that Majors was emotionally or mentally abusive. And it also seems to contain this mention of the police incident in London of September 2022. And yesterday, the Rolling Stone tried to add that the London incident did, in fact, involve Grace Jabbari, but they can't say how they confirmed it. And they also state that the London police didn't confirm it. That was something I had to wrap my head around yesterday. You can take a look at that in my last video or jump over to Twitter or jump into any of the links that I'll share with you. But that's really where we get to this trial by newspaper. And we're starting to already see that Gaffey is questioning things. And remember, these early hearings were juggled back and forth between Judge Pauly and Judge Gaffey. But on the August 3rd hearing, Judge Gaffey made the decision to keep photography, keep videos out of the courtroom. And while the hearing was underway, the courtroom was on lockdown for movement in and out. We see that same thing echoed on September 15th. We have Laura Italiano, who's a senior correspondent with Insider. On September 15th, she reported a wrinkle in today's coverage of Jonathan Majors' latest misdemeanor domestic assault case hearing just now in Manhattan. Judge Michael Gaffey has sealed the courtroom, kicking out the press. Prosecutors and the defense are remaining in the courtroom. Judge Gaffey said, quote, "This is going to be a proceeding that will be under seal because the law requires that the issues we are about to discuss on the record must be sealed." Back on the record 45 minutes later, Major's on screen listening his paperwork schedule is set for the defense motion to dismiss. And then if you want to revisit that, this is the day that the high school kids fight video that Jonathan Majors broke up, and then the street surveillance video of Grace Jabbari on the sidewalk with the 3 strangers she ended up going out with. That's the day both those videos dropped, but if you want to revisit that, you can check old videos. But the main point being is that we've already seen a pattern where Gaffey is trying to prevent this from becoming a trial by newspaper. And on one hand, that could be because it involves a special victim, right? This is a DV case. On the other hand, it's a high-profile trial, and, if the jury pool is tainted beyond repair, that's a major issue for appeal. So knowing that Priya Chaudhry told us explicitly she cannot speak about the Jonathan Majors trial right now, and then seeing the way Rolling Stone kind of wrote what they wrote yesterday, I think this is something that Gaffey's taking a firm hand on. Gaffey agreed, finding that the evidence was likely to be, quote, inflammatory and could taint a jury pool if it were reported in the media. The Manhattan District Attorney did not take a position on the matter. An attorney hired to represent the press, Catherine Bolger, opposed the move to seal evidence, noting that the public had a right to know the evidence in the case. Now, Catherine Bolger, is pretty well known for First Amendment cases. To me, this isn't just a nobody showing up asking for access to court records, a star advocate for press outlets. And then the author of this article notes that Majors is known for carrying his coffee cup on the red carpet and to media interviews. So we've seen previously that he's carried a Bible to court. He has this coffee mug in his hand here with his Bible. And then he's holding Megan Good's hand with his other hand. Now that was a good summary. Let's look at 2 other threads from other reporters that are down at the courthouse. We'll start with Emily Palmer. She's the one that provided us the video of the arrival. And let's go through what she's gathered. Calling Jonathan Majors' assault trial very unusual, the judge contrasted the actor to indigent New Yorkers who months later couldn't cross-file allegations against their accuser. Prosecutors won't prosecute Grace Jabbari, who Majors says attacked him, when she says he attacked her. Before Jonathan Majors' trial for assault charges starts, the judge will hold a hearing he has closed to the public, noting that the allegations to be discussed are likely inflammatory and would preclude the actor from getting a fair trial. Jury selection is slated for today. So she published this about an hour ago, but Jonathan Majors is now in a closed hearing, which precludes the public, including actress Megan Good, who came to court hand in hand with Majors this morning. Walking into court, Majors carried a coffee mug, notebook, yellow Post-it pad, and what looked to be a gold leaf Bible. And then we have a take from Flavio here, so shout out to him. His take is, Gaffey knows perfectly well that Jonathan is completely innocent. He tossed reporters out of a pretrial hearing in September in the case, saying that barring the public from yet another motion hearing is, quote, the only way to safeguard Majors' rights. Now you could take this in 2 parts, right? You could digest this part separately from this part. With the latter part, the judge has the discretion to do this, and the judge probably has the foresight to, in a high-profile case, want to be extra careful of the idea that press releases could go farther than they normally would for someone else that the news wouldn't care to talk about. And I would reason that discretion makes sense, even if Gaffey doesn't know or doesn't think that the person on trial is innocent or guilty. That part doesn't really matter. This could be a move that's not always necessary to ensure a fair trial, but it's probably more necessary here than otherwise. Now, I save Victoria's thread for last because it's more detailed. It's clear she's writing shorthand to try to get details out and reported. So as we go through this, keep that in mind, that it's quick and efficient writing. And she also gave us an update 3 minutes ago as of right now. So let's dive in. I'll get this video out there and it'll be really recent for you guys. So their first post about what's going on at the courtroom. Aggro exertion of authority over press has started. I actually said, this kind of energy isn't necessary. TK, crystals. Anyway, we're not going to bust open the courtroom. This is jury selection in a misdemeanor trial with an actor who wasn't a household name. Also, turned up armed men being like, respect my authority at a DV trial is a look, I suppose. Sometimes you just want to tell people the Shield isn't on TV anymore, so no audition to practice for. Anyway, and Jonathan Majors has entered the courtroom. He was wearing large lens tortoiseshell glasses, a black winter coat, and a gray suit underneath. Major's suit is double-breasted. Marjo's, I think this was say Major's. Major's walked into court with girlfriend Megan Good. She's wearing round glasses. Major's carried a Bible, a small notebook, and a ceramic cup. Jonathan Majors, Megan Good, and team left the courtroom for about 15 minutes. Everything is expected to start at 10 a.m. This is Eastern. He re-entered. He and Good are seated in the front row. She's got her arm around him. Jonathan Majors has entered the well and taken a seat at the defense table. And at 10:15, we're going to get to an important thing right now. There's evidentiary paperwork under seal. Majors wants to keep it sealed. Prosecution takes no position. Papers under seal right now, media lawyer soon going to be heard on unsealing. Jonathan Majors' team, in arguing for the sealing, has previously said, quote, "This is a highly sensationalized case where the media both nationally and internationally has taken an inordinate interest in case. One of Jonathan Majors' lawyers says the defense recognizes First Amendment, but with release of materials at issue, this is obviously squarely pitted against Mr. Majors' Sixth Amendment right to a fair trial. The public's right to access, quote, isn't limitless. Basically the same anti-access fugazi we always see. Some context, Majors' own team has litigated this case in ... the press. Recall when Priya Chaudhry suggested to press that the case was about race, which is pretty sensational and inflammatory. Catherine Bolger, lawyer for press, notes this is an open court and argues against defendants' claim that Sixth Amendment trumps First Amendment. Case defense cited, Bolger said, quote, "Doesn't say the Sixth Amendment trumps First Amendment. That's not true. Otherwise, there wouldn't need to be a balancing test." She also makes the very important point that we don't even know what the under seal materials are about, which is problematic in and of itself. Well, we kind of do because the Rolling Stone has been reporting on it. The one yesterday says that it's, the packet contains these statements and they believe it also contains this London thing. It's my own speculation that they had to say it believed it contained information about the London incident because they didn't want to come out and say the prosecution told them that it did. But at the very least, we know that these witnesses that the Rolling Stone reported on in the summer, their statements are included in this. Judge asks Bolger about the fact that she reps some press, but not all in courtroom. Therein lies the problem, intimating that people she doesn't represent can't be trusted. This is fucking wild. So let's assume that we have an open courtroom for this limited issue, and there's something that comes out during the hearing that are highly prejudicial, and the members of the press hear that, and then I rule that it is not admissible at trial. Can you assure me that the press would not write about the inadmissible issue? Everyone, this is abso-fucking-lutely insane. The judge is basically suggesting that shit would be closed if it's not guaranteed the press write about inadmissible info. This is insane. Honest to God, I am fucking floored right now. Judge tells Bolger, who said press was flying blind due to opacity surrounding info, you're flying blind, and yet the press, you're flying blind, and yet there are articles out there, ... Judge says articles show, quote, they're writing about stuff that has never been litigated in court, end quote. This is absolutely wild. Basically, the suggestion is that sealing or not sealing will come down to whether the press is going to write about stuff that isn't admissible. There's literally no law saying that the press can't write about inadmissible things, nor is there a law saying that the possibility of writing about inadmissible things is justification for closure of courtroom or sealing of docs. Judge supposedly going to decide later, but hey, everyone likes to shit on the press these days, so I'm not optimistic anyway. It's a good point. I don't think it's undeserving sometimes when people shit on the press, but I do think there are people that particularly enjoy doing so. But back to Victoria's thoughts. And we're getting an update on scheduling during housekeeping discussions, per Chaudhry. The people have noted that they expect to call at least 14 witnesses and that their case will take at least 6 days. And remember, yesterday we heard that this is going to be like a 3-week trial. And that's including today and jury selection time and all this decision making. Given that, and given the defendant also intends to put on a case, we are concerned that we will need more than 2 alternates, jury alternates. And the court staff has advised that in this courtroom we cannot have more than 2. We are now talking potentially weeks for a misdemeanor DV trial. So I think maybe the 2 alternates, because it's a small courtroom probably, and so if they need to have more alternate jurors seated, but they can't physically seat more people in this courtroom, and they need to go to another courtroom to hold the trial if there will be more alternates, a different courtroom might not just magically be open tomorrow, right? This would have to fit the calendars. Maybe the judge will be like, come on, especially since jury selection's already underway and we have Christmas around the corner. So at 12:02 p.m. Eastern we have, and we're back, judge has taken bench. We expect to hear his decision on the sealing stuff soon. Breaking, judge shits on First Amendment. Quote, the court has considered the extensive press coverage of this case and believes that the press would report on this evidence whether or not it's admitted at trial. The court concludes that sealing the hearing and documents related to the single pretrial issue is the only way to prevent tainting the jury pool. On to the next thing. Prosecutors want to keep Jonathan Majors' accuser's arrest from being mentioned in court. They declined to prosecute and told cops this even before her arrest. His lawyer said, "We do intend to bring out this information. Stand by." Judge seems skeptical about situations surrounding Majors' accuser's arrest, which came months after he was arrested. Did this only come about because of the high-profile nature of this case? And if this was an indigent, everyday New Yorker, would this have happened? Judge didn't decide whether arrest can be mentioned. Did decide prosecutor can't call accuser, can be referred to as victim during jury selection. So this was jumbled to me, but I think it's supposed to mean that the judge did decide that the prosecutor can call Grace Jabbari a victim during jury selection. But I'm not sure. Now, this was at 12:34, where we have Victoria report on that decision. But then at 3:26, we have, after an hour-plus long proceeding that was closed to the press, court's resuming in a few. Prospective jurors have entered the courtroom. Judge Gaffey is swearing in the pool of potential panelists. And then at 3:38, so 4 minutes after that, the judge has sent them home for the evening, telling potential jurors to come back in the AM. Gaffey says we're done for the day, come back at 10 a.m., we'll start jury selection then. Gaffey says they've got 40 potential panelists, and then we've got him leaving court. That must be Seth.
How's your poetry going?
I wonder who took this video. I wonder if this is Victoria's video and if she asked. Because that voice is like right there, coincidentally. So there's a few things we can talk about. One, since it's kind of how we started, Jonathan Majors gets a lot of poking and prodding because of the way he dresses. There's a joke that he dresses like he's destitute, but he's clearly cleaned up, very sharp looking for this trial. He's showing up with the support of an intimate partner. He's holding a Bible in his hand, which is not all that unusual. That's something that you can kind of see a lot. A lot of defendants may consider doing. But what are your thoughts on appearances? Do you think it's impactful? Do you think it matters? Number two, what do you think about the type of coverage that we're able to get? I personally lean towards transparency when it comes to criminal prosecution, but I think that transparency should apply to the prosecution just as much as it might apply to the person on trial, at least for the acts being alleged and for the accusatory parties. So that leads me to point three, and they're going to tie in. What do you think about this press and media war? What do you think about Catherine Bolger showing up? We have a whole press attorney showing up to argue that this stuff being filed under the Molyneux rule should be unsealed for the sake of the First Amendment for public access. What do you think about that? And keep in mind that just because something is currently sealed doesn't mean it will always remain sealed. It's kind of remaining sealed because it hasn't been admitted to court yet. And this sealing doesn't mean that it won't be admitted to the court. It just means that the press won't get their hands on it through the court's public record. That's what that type of thing prevents. It may still come out by some other means. It may come out because it's released after the trial ends. But what was decided today is that it won't be available as public record for the press to come out and say, hey, this is everything that's in this packet that the prosecution has of evidence that they want to use against Jonathan Majors. But what do you think about that issue, the First Amendment versus the Sixth Amendment? And what do you think about that issue being raised in this case? What do you think about that issue when it comes to someone that may, as Gaffey said, be an indigent, everyday New Yorker? You can share any and all of your thoughts on that. And the reason I said point 2 and point 3 tie together, and I didn't want to speak on this while I was going through the case because I don't want it to conflate. This is just my opinion here, but I'm someone that leans in favor of transparency over privacy, at least in terms of criminal prosecution, right? And when I say I lean in favor of transparency, that doesn't mean I want to know what the prosecutor had for breakfast. That doesn't mean I want to know what the defendant had for breakfast. And that certainly doesn't mean I want to know what the victim had for breakfast, what the alleged victim had for breakfast. But I believe that in a criminal prosecution, that in the criminal justice system, the prosecution should be the most transparent party in that courtroom. That's just what I think. And when we focus into special victims type cases, DV cases, there's a necessary balance shift. And I agree that you do want to implement some type of additional privacy for the alleged victim. Because even though it's sometimes necessary, a victim shouldn't have to put their entire life and experience under the public lens just to get justice, right? So the balance shifts a little bit when there's a special circumstance, like a DV or sexual assault case. But when we focus in really far and we think in terms of the Manhattan DA, and then we think in terms of the Jonathan Majors case specifically, here it's my opinion that the prosecution seems to have a pipeline, and it's not one way, it's two-way, where the judge is pointing out that things that shouldn't be in the press that are under seal are out in the press. And to me, that seems to be referring to these statements that we know are under seal and this London incident that Rolling Stone is suggesting is part of this evidence packet that's under seal. To me, there's no reason to think it pertains to the surveillance footage that was obtained by a third party and released by Insider. Maybe that's part of something that the district attorney filed under seal, but I don't think that it is. We know that the judge is upset about something that is filed under seal that's been in the press. Process of elimination, guesswork. And the reason I think that's so important to point out is because the prosecution didn't take a stance today in favor or against the unsealing, but this press attorney was showing up. So I don't think it was necessary that the prosecution had to take a stance because they knew a star attorney, a star First Amendment attorney, was coming on to speak in favor of the unsealing on the grounds of First Amendment access to public records. The prosecution, to me, they did not need to take a stance. They had the opportunity to let the battle live between the defense team and the attorney for the press. But the prosecution has kept Grace Jabbari unnamed. The Rolling Stone reiterated yesterday that they are also still keeping Grace Jabbari unnamed because the prosecution is doing so. So it's just really interesting to me to see an adamant approach to keeping Grace Jabbari unnamed, but yet there's this fight, or there was this fight. I guess it's over for now in terms of press access to the public records currently, but they really wanted to motion the court to let us see anything and everything that the prosecution wants to submit against Jonathan Majors. And currently at this point in time, he hasn't been convicted of anything. And although the state does not characterize Grace Jabbari as a criminal, they declined to press charges. Jonathan Majors filed a complaint alleging that he was the victim. So it's an interesting scenario where subjectively, the press could be fighting on one hand to oblige the state's wishes to keep Grace Jabbari unnamed, particularly the Rolling Stone. But at the same time, they're fighting to get any information they can about Jonathan Majors. Even though one could say, and the state is not saying this, but others could say that he might be a victim of DV. And again, the judge has some discretion here. And the judge did not say this is private forever, no one's ever going to see it. He did not say the jury's not going to see these things. We'll still have to wait and see, item by item, what's allowed to come in. But if we zoom back out a little bit, if we go from the Jonathan Majors case and we go back out to Priya Chaudhry and the Manhattan DA, Priya stated that Adam Foss is suing the Manhattan DA. Adam Foss was acquitted early in November, fully acquitted in this district from felony rape charges, and I think the other one was assault. So there's no need for an appeal, but he is suing the Manhattan DA. Now, with the Jonathan Majors case, the judge might be very tuned in to the possibility of an appeal because it's clear that Adam Foss and Priya Chaudhry aren't letting up on the idea that the trial brought against Adam Foss was a witch hunt. And now we have Kaiser Gondrick alleging the same thing in the same district about the same DA, which is another high-profile case, right? That involves, she's a WNBA player. Michael Porter Jr. is a current star NBA player, rising star. Adam Foss was high profile because of his TED Talks and he had some celebrity influencer status, but it was also high profile because he was a prosecutor himself. And then you have Jonathan Majors, who's in Marvel films and was a rising star. So all of that context is pretty important, I think, to note because the judge might be hyper aware of possible appellate issues. And don't forget, Jonathan Majors already lined up Dustin Pusch. I don't know if that's how you say his name, but right after that Rolling Stone article came out with all those witnesses, Dustin came out and he has already sued the Rolling Stone successfully before. He came out and pushed back on behalf of his client, Jonathan Majors, against the Rolling Stone article. A lot of interesting stuff to watch here. If you want to check out what happened with the Adam Foss case, I went back and compiled everything together here. I realized the bombshell while I was reading it because that trial was not live streamed either. I haven't found transcripts yet. I couldn't even find out who the judge was to be able to request information as public records access. And maybe I'll keep looking for that. But there was actually a good amount available online because a lot of the case was grabbed from public blog posts and public posts on Twitter or X. And I kind of realized a bombshell contradictory piece of evidence while I was going through what was publicly available. And you can check all that out here. If you want to take a look back at how this case has moved forward, the Grace Jabbari arrest, the motion to dismiss, the surveillance footage, the injuries, some of the evidence that we are able to see. I have a whole playlist with all these videos. You can also hop over and follow me or anyone I've mentioned on Twitter or X to keep getting updates. But there's definitely a lot here to digest from this small, short pretrial morning that we had today. Voir dire jury selection will really kick off tomorrow now that everyone's been sworn in. So I'll keep covering it. Make sure you subscribe on the way out. Share your thoughts in the comments. I don't care if you agree or disagree or split decision, whatever it is. And take care until next time.